All please rise. The Honorable, the Associate Justices, the Senior Associate Justice, and the Chief Justice of the Supreme Court of the Philippines. Hear ye, hear ye, hear ye. All persons having business before the Honorable Supreme Court of the Philippines shall give their attention, for the court is now in session.
Please be seated.
Madam Clerk of Court, please call the cases before us.
Good afternoon, Your Honors. Scheduled for today's oral arguments are the consolidated petitions in GR number 256, Republic of the Philippines, represented by the Department of Agriculture, the Bureau of Fisheries and Aquatic Resources, and the National Telecommunications Commission versus Royale Fishing Corporation, Bonanza Fishing and Market Resources Incorporated, RBL Fishing Corporation, and the Honorable Regional Trial Court Judge Zaldi B. Docena, Branch 170, Malabon City, respondents. GR number 256559, Republic of the Philippines, represented by the Department of Agriculture et al., petitioner, versus Royal Fishing Corporation et al., respondents, and GR number 257049, Oceana Philippines International, Pablo R. Rosales, and Ronaldo P. Reyes, petitioners, versus Royal Fishing Corporation et al., respondents.
Counsels, please enter your appearances.
Good afternoon, Your Honors. Respectfully entering our appearance as counsel for the petitioner Republic of the Philippines through the Department of Agriculture, the Bureau of Fisheries and Aquatic Resources, and the National Telecommunications Commission, I am Solicitor General Menardo Guevara. Together with me in this afternoon's oral arguments are Assistant Solicitor General Bernard Hernandez, Assistant Solicitor General Elaine Rose Sanchez Coro, Senior State Solicitor Melanie Pimentel, and Senior State Solicitor Cheryl Angeline Roque Javier. Also present, Your Honors, for purposes of serving as resource persons, if found necessary, are the following: Department of Agriculture Undersecretary for Fisheries, Drusilla Esther Bayate, BIFAR National Director Demosthenes Escoto, BIFAR Assistant Director Saldi Perez, Mr. Marlo Demoos, OIC of the VMS Operations Center, Ms. Cheryl Mesa of BIFAR NSAP, Mr. Francisco Torres Jr. of the NFRDI, Mr. Roland Geronimo, IUUF Specialist, Attorney Felizardo Pulumbarit Jr., BIFAR and Office of the Undersecretary for Technical, and Attorney Andres Castelar Jr., NTC Director for Legal Branch. We are ready, Your Honor.
What about the other party?
Good afternoon, Your Honors. Attorney Michael Christopher De Castro, With me are Attorney Pauline Tejido, Attorney Mario Mariderazo, and Attorney Donatello Justiniani, appearing for petitioners intervenors Oceana Philippines International, Rosales, petitioner intervenor Rosales, and petitioner intervenor Reyes.
Okay.
We are ready, Your Honors.
Respondents.
Good afternoon, Your Honors. I am Attorney Arnold D. Naval. With me this afternoon is Attorney Neil Henzola, Attorney Herschel Magracia, Attorney Ruben Soriano, and Attorney Patricia Ruelo. We are respectfully appearing for the respondents RBL Fishing Corporation, Bonanza Fishing and Market Resources, Inc., and Royale Fishing Corporations. We'd like to acknowledge also, Your Honor, present this afternoon are the representatives of RBL Fishing, Mr. Ferdinand Lim, and the representative of Bonanza Fishing, Mr. Paulo Santos. We are ready, Your Honor.
Thank you. So as discussed during the preliminary conference on September 26 and stated in the advisory, counsel for petitioners in the consolidated petitions will be heard jointly for 30 minutes. The Office of the Solicitor General, representing the Department of Agriculture, the Bureau of Fisheries and Aquatic Resources, and the National Telecommunications Commission shall be given 20 minutes of the 30 minutes allotted for the petitioners. Counsel for Oceana Philippines shall be given the remaining 10 minutes. Counsels for respondents Royal Fishing Corporation et al. Shall be heard immediately after the completion of the counsel for petitioners' arguments. Counsels for Royal Fishing et al. Shall similarly have a total of 30 minutes to present their arguments. The time allotted for counsels to argue shall be exclusive of the time devoted to interpellation by the members of the court. The interpellation by the members of the court shall immediately follow after both parties complete presentation of their arguments. Either petitioners or Royal Fishing et al.'s counsel or both may be called upon during the interpellation. Counsel for petitioners may now approach the podium for their presentation.
Mr. Chief Justice, members of this most honorable Supreme Court, good afternoon. Our Constitution explicitly declares the state shall protect and advance the right of the people to a balanced and healthful ecology in accord with the rhythm and harmony of nature. This is not an empty rhetoric. As an archipelagic country, the Philippines has been endowed with abundant marine resources. Utilization of such resources has spawned robust maritime industries, has generated livelihood and sustenance for its citizens, and has contributed immensely to the country's economy. In 2021, the value of Philippine exports of fishing products amounted to around $1 billion. However, the rich resources in our country's fishing grounds have notably declined over the years. Many of our fishing grounds have gone beyond sustainable fishing levels as a result of intense fishing pressure. As owner of these natural resources, the state is bound to protect the nation's marine wealth. This is precisely the reason why we stand before this honorable court today. In line with our obligation to protect the country's marine wealth, Congress enacted the Philippine Fisheries Code in 1998. Then in 2015, Congress amended the Fisheries Code to define and impose heavy penalties on unlawful, unreported, and unregulated fishing, or IUUF. To achieve the objectives of the law, the government has issued relevant implementing regulations. In particular, Fisheries Administrative Order, or FAO, number 266, was issued to curb, if not eliminate, illegal, unregulated, and unreported fishing, as well as to serve as a management tool for conservation purposes. FAO 266 requires the use of a vessel monitoring system, or VMS, and an electronic reporting system, or ERS. These are fisheries management tools that have been developed based on scientific studies and are globally recognized. These tools and aid state implementors and enable them to monitor all duly registered commercial fishing vessels to ensure that they are operating within authorized fishing grounds. Data gathered from the VMS will guide state implementors in the adoption of conservation and management measures and in the prosecution of fisheries law violations, including commercial fishing in municipal waters. As we have emphasized in our submissions, irresponsible use of our marine resources endangers their very existence. Enjoining FAO 266 removes one of the most effective tools of the government against IUUF. Mr. Chief Justice, Your Honors, we likewise come here before you with a sense of urgency. Around $320 million worth of fish products bound for export to Europe every year are in danger of being rejected if the Philippine government fails to certify that such fish products were not caught through IUUF. As I will discuss later, the Philippines is a state party to various treaties and agreements recognizing the right and duty of states to adopt conservation and management measures for the protection of the marine environment and the long-term sustainable use of living marine resources. A declaration of unconstitutionality of FAO 266 frustrates the state's efforts to honor its international commitments and render it powerless to uphold the shared goals these commitments represent. For failure to honor such commitments, the country may lose access to foreign markets for its fish exports. Mr. Chief Justice, Your Honors, we will demonstrate today that FAO 266 was erroneously declared unconstitutional and that respondent judge committed grave jurisdictional trespass. First, administrative regulations have the force and effect of law. They enjoy the presumption of legality. In issuing FAO 266, BIFAR acted pursuant to its duty in accordance with the mandate of the Fisheries Code, as amended by the IUUF law, using its technical expertise and best judgment informed by science in order to ensure a healthy marine environment that can sustainably provide fish for all. This court, in many of its decisions, first Lepanto Ceramics versus Court of Appeals, Nestle Philippines versus Court of Appeals, among others, has deferred to the government agency charged with the implementation of the law and recognized the government agency's competence, expertise, experience, and informed judgment. Thus, unless and until administrative regulations are proven to have clearly and manifestly exceeded the bounds of the law, including the Constitution, their validity and legality must be upheld. This respondents failed to do. Second, FAO 266 does not violate the respondent's right to equal protection of the law. There is a substantial distinction between municipal fishing and commercial fishing. Municipal fishing uses light vessels of 3 gross tons or less, is carried out within shallow municipal waters, and is regulated primarily by the local government units. The subsistence scale of municipal fishing activities does not impose a heavy pressure on aquatic resources. Commercial fishing, on the other hand, is much larger in scale and is regulated by the national government through the BFAR. It involves a greater burden on aquatic resources, given the kind of fishing gears used and the range of its operations. This substantial distinction, germane to the purpose of the law, justifies differential treatment of municipal and commercial fishing. Moreover, mere under-inclusiveness is not a violation of the equal protection guarantee, as recognized by this honorable court in Biraugo versus Truth Commission. Third, FAO 266 does not amount to a deprivation of life, liberty, or property in the constitutional sense. Respondent's claim is anchored on a mere privilege granted by the state to exploit resources owned by the state. On procedural due process, owners of commercial fishing vessels were given an opportunity to be heard through several consultations and dialogues held in various regions throughout the country. Respondents themselves admitted participation in the nationwide consultations prior to and after the enactment or issuance of FAO 266. Fourth, artificial or juridical entities like respondents have a limited right to privacy, as held by this honorable court in Valmonte et al. Versus Belmonte Jr., granting without admitting that these fishing companies may invoke such right in their favor. FAO 266 does not violate the right to privacy and the right against unreasonable searches. When commercial fishing vessels are granted the license to engage in fishing activities, they submit to the full control and supervision of the state. They therefore have no reasonable expectation of privacy. Their commercial fishing vessel license states, the owner, operator, and patron or captain of this fishing vessel shall conduct fishing operations in accordance with the provisions of Republic Act Number 8550, otherwise known as the Philippine Fisheries Code of 1998, as amended by Republic Act Number 10654, Fisheries Administrative Orders, and the terms and conditions embodied at the back hereof. A fishing vessel's fishing area, fish catches and spoilage, landing points, and estimated quantity and value of fish caught have long been required to be recorded and reported to BFAR upon the completion of each fishing trip. FAO 266 merely seeks to digitize and report this in real time. Having submitted themselves to the full control and supervision of the state, there is no basis for respondents to claim illegal intrusion into their fishing activities and unlawful search of data relating thereto. Lastly, the Honorable Court in Morphe versus Muto ruled that the right to privacy, although considered fundamental, may succumb to an overriding state interest deemed legitimate and compelling. Fifth, information required to be reported to the BFAR as a condition for the issuance of a fishing license or privilege are not trade secrets. The BFAR is the regulator. It is not a business competitor of respondents. Moreover, through the use of available technology, one can easily track where fishes are abundant. Known habitats of fishes can be determined through oceanographic data. Location of fishing vessels can be tracked with such devices as visible infrared imaging, radiometer suite, and transceivers. All this data and information are readily accessible to the public. They cannot be considered trade secrets. Nonetheless, adequate safeguards are provided by law and regulations to prevent unauthorized disclosure of this information. Data obtained through the VMS may only be accessed by the authorities and the fishing vessel owner or operator who submitted the same. Under the Fisheries Code as amended, these are considered sensitive technical information. Its unauthorized disclosure is punishable under the Fisheries Code with imprisonment of up to 6 years. Sixth, the Philippines is a party to various treaties and agreements recognizing the right and duty of states to adopt conservation and management measures to protect their marine resources. These include the United Nations Convention on the Law of the Sea, or UNCLOS, the Agreement to Promote Compliance and International Conservation and Management Measures by Fishing Vessels on the High Seas, the UN Agreement for the implementation of the provisions of the UNCLOS relating to the conservation and management of straddling fish stocks and highly migratory fish stocks, such as tuna, and the Convention on the Conservation and Management of Highly Migratory Fish Stocks in the Western and Central Pacific Ocean and its annexes, ratified by our own Senate. The Philippines is likewise a member of several regional fisheries management organizations. A declaration of unconstitutionality of FAO 266 renders the state powerless in its efforts to honor its international commitments, contrary to the principle of pacta sunt servanda. It is left defenseless against the decline and deterioration of the country's marine resources and ineffective in the enforcement of the right of the people to a balanced and healthful ecology. It stands to suffer economically for failure to comply with traceability requirements of countries to which our fisheries products are exported. Mr. Chief Justice, Your Honors, the petitions before this honorable court present issues of transcendental importance. Respondents allege rights to privacy, due process, equal protection, and against illegal searches, even as nearly 2/3 of all licensed commercial fishing vessels have faithfully and dutifully complied with FAO 266, are pitted against the constitutional duty of the state to protect and preserve marine resources for the benefit of everyone, including respondents themselves. Consistent with the right of the people to a balanced and healthful ecology, the state ownership of all natural resources, as well as its international obligations under various treaties and agreements, the government has a legitimate interest in combating IUUF fishing. Likewise, through FAO 266 and the installation of vessel monitoring systems, the state is able to access accurate real-time data, which will strengthen its efforts towards the conservation and management of fisheries and aquatic resources in the Philippines. Mr. Chief Justice and honorable justices of this court, these cases also present a question of first impression. A regional trial court arrogated upon itself a power reserved exclusively to this honorable court, with grave abuse of discretion amounting to lack or excess of jurisdiction. It issued a temporary restraining order and writ of preliminary injunction against the enforcement of fisheries laws without an indubitable legal basis to do so. Though the issue of preliminary injunction has been mooted by the rendition of judgment by the trial court, it behooves this honorable court to make a ruling in order to guide the bench, the bar, and the public in future environmental cases that may arise. Petitioners therefore pray of this honorable court that, number one, a temporary restraining order or a writ of preliminary injunction be immediately issued against the decision dated 1 June 2021 of the Regional Trial Court, Branch 170 in Malabon City, and number two, said decision be annulled, reversed, and set aside. Thank you, and may it please the court.
Mr. Solicitor General. Next. Yeah, but
One moment, Your Honor, while I prepare our audiovisual presentation. Honorable Justices of the Supreme Court, Chief Justice Esmundo, Senior Associate Justice Leonen, and the Associate Justices of the highest court of the nation. May it please the court. On behalf of all citizens and all municipal fisherfolk of the country, allow me first to express our profound gratitude for giving us a voice and for lending an ear to our plight. We Filipinos have a deep connection with the sea. Who among us in this august room doesn't know the smell of tuyo in the morning, or the taste of sinigang na gulyasan or cocido for lunch? Recall, Your Honors, the unique joy of smoked tulingan or inihaw na tambakol during a trip to the beach. Even the simple yet dependable fried galunggong has a place on all our dining tables. Now imagine, Your Honors, a future where our grandchildren's grandchildren cannot know these Piscean joys. That future is in front of us, and it requires our immediate attention and action. Fishing stocks all across the country are in decline. In fact, we are currently in the longest nationwide decline of fishing stocks in our history. For the last 11 years, over 94% of fish stocks in Philippine waters have been overfished. Of the 17 stocks of galunggong, for example, only one remains viable. For sardinas, only 3 of the 15 stocks remain viable. An overfished stock cannot replenish itself after a season. Repeat for enough number of seasons, and a stock eventually collapses, never to return again. The actual case or controversy before this court today, Your Honors, is none other than the tragedy of the commons and the legitimate government interest of preserving fishing stocks by preventing illegal, unreported, and unregulated fishing is not in dispute. Vessel monitoring measures have a rational connection with the prevention of IUUF. Now, the respondents take umbrage at the manner in which government implements this legitimate and existential interest. First, the respondents argue that the regulation in question violates their right against unreasonable searches and seizures. They say that they have a reasonable expectation of privacy over trade secrets concerning the location of fishing grounds. But how can that be when all waters belong to the state and any benefit that can be derived from it can only be done so at the government's pleasure? The Constitution, Your Honors, does not protect the pursuit of profit. Further, how can the respondents claim a reasonable expectation of privacy over fishing grounds when all across the globe, and even in our own country, ships already use automatic identification systems with built-in geolocation transponders as a matter of course? Your Honors, these are all the AIS-equipped ships in the country. Now, this is a subset of all tankers, all cargo vessels, and fishing vessels. Through AAS, we can see important details regarding particular vessels. We can see the ship's course, as for example, this is the course of the oil tanker Pacific Anna, which collided with fishing vessel FFB Dearden last week. Further, we can see actual fishing grounds where fishing vessels catch. This is the fishing ground of fishing vessel Cedar 5 near Batangas City. This is the fishing ground of fishing vessel Maria Erlinda near Papua New Guinea. This, Your Honor, is a Chinese fishing vessel, Gyeongsan Shayu, fishing well within our EEZ near Palawan. Obviously, Your Honors, fishing vessels are moving vehicles, and they are easily capable of evading the Philippine Coast Guard or traversing protected marine areas. Further, Your Honor, how can the respondents claim reasonable expectation of privacy when satellites have a plain view over everything they do? See, for example, Karagatan Patrol, a website which embeds light and infrared emissions of fishing vessels detected by passing satellites onto the official Philippine map made by NAMRIA. Each red dot on this map, Your Honor, is a vessel, is a detected vessel. The blue line here, Palawan, barely visible, is the municipal delineation. And the green polygons to the side are protected areas. Again, Your Honors, this is all data from the government. Second, the petitioners claim that their constitutional right to equal protection has been violated by the implementation of VMM. As a starting point, both Article 12 of the Constitution and the Fisheries Code describe fishing as a privilege. the state is well within its constitutional prerogative to place conditions on the exercise of privileges. If tomorrow the state decides to withhold all fishing privileges, it is constitutionally permissible to do so. One such condition is registration. Commercial fishing vessels must be registered with the BFAR before they may operate as such under Section 23 of the Fisheries Code. As of August 2023, Your Honors, the respondents, specifically Royale, have registered only 13 out of 230 of their fishing vessels with BFAR. Further, the classification between commercial fishing vessels and municipal fishing vessels, on the other hand, rests on substantial distinctions. This is Mona Linda 91, one of the biggest fishing vessels of RBL Fishing Corporation, and it stands at 992.58 gross tons. Now let me show it beside a common bangka. It's barely visible, Your Honor. And one Mona Linda 91 is equivalent to 331 bangkas. Taken together, in fact, the fishing vessels of just these three companies alone are equivalent to 11,389 bangkas. There are approximately 40,000 bangkas all over the Philippines. The Fisheries Code, Your Honors, is not only an environmental law. It is social legislation. When the Constitution speaks of giving priority and of protecting subsistence fishermen, it lays down a policy not even Congress can set aside. Like the right of the people to a balanced and healthful ecology, it is a political question that is hard-coded into the DNA of the Constitution itself. Ultimately, Your Honors, the petitioners, we, the citizens, the municipal fisherfolk of our nation, we yearn only to pass the joys of tuyo and tambakol to our posterity. And we pray, Your Honors, that this honorable court prioritize all our posterity over the respondents' pursuit of profit. Thank you, Your Honors, and may it please the court.
Thank you, Mr. Counsel. For the respondents, are you ready? Please approach the podium.
Honorable Mr. Chief Justice, Honorable Justices of the Supreme Court, esteemed colleagues of the bar, good afternoon. May it please the court. Today we address the validity of FAO 266. We appear not merely as advocates for our clients, but as guardians of the fundamental rights. To outsiders, fishing appears like a simple task of casting a net or a hook into the sea. But the ability to read the subtle signs of the ocean and employ techniques passed down through generations defines its success. It depends on the knowledge of ever-changing currents, lunar cycles, temperatures, and fish habits, which play crucial roles in determining where to fish. Understanding the local ecosystem and fish behaviors, kept as secrets from the community, form the core of fishermen's livelihood. These developed through a lifetime of learning, giving one distinct advantage over others. Combined, these factors create a delicate balance between man and nature, resulting in bountiful catches while maintaining the vitality of our ocean's ecosystems. Respondents only catch galunggong and small pelagic fish in Philippine waters to be sold in local fish ports and talipapas, and not for export. They catch these species only in shallower waters. But their sector represents the backbone of capture fisheries and contributes significantly to domestic food security. We must distinguish them from tuna fishermen who catch oceanic tuna mainly for export. Tuna fishermen operate primarily in deeper waters and migratory pathways, and these pathways traverse international borders, underscoring the necessity for monitoring measures. As a tuna caught in one country can be transshipped in another country, processed in a third country, and exported to a fourth country. The claim in the decline of marine resources over the years and that fishing grounds have gone beyond sustainable fishing levels has no conclusive basis. They merely rely on the report of the volume of fish caught and reported by PSA. We have yet to determine the number of fish inhabiting a particular area. Statistics may show fluctuations, yes, but not alarming. But this may be caused by decrease in total catching effort brought about by rising fuel costs, salaries, and overhead expenses. The OSG describes FAO 266 as a noble regulation to manage our fisheries resources. Still, we will show that it violates the constitutional rights to privacy and against unlawful searches, the Equal Protection Clause, due process, and to participate in decision-making. This sits on top of the Ombudsman case for graft and corruption hounding the 2 billion procurement of the VMS equipment for FAO 266. On the first procedural issue, we maintain that the petition for declaratory relief is the proper remedy to assail FAO 266 constitutionality. The petition before the trial court meet all the requisites. First, the subject refers to a regulation, FAO 266. Second, the doubt as to its validity because of its constitutional violation. Third, no breach of FAO 266 by the private respondents. Fourth, the injury to be sustained as a result of its implementation. Fifth, the issue being ripe for judicial determination, having proven how the commercial fishing operators will suffer irreparable damage. And sixth, no other adequate relief may be availed of because only the courts have the power to resolve constitutional issues. On the need for the private respondents to exhaust all available administrative remedies before they file the petition for declaratory relief, this principle does not apply. As the issues involve the constitutionality of an administrative order, Diocese of Bacolod versus Comelec held that an exception to exhaustion of administrative remedies is when the issue is purely legal. On whether the commercial fishing operators possess locus standi to question the constitutionality of FAO 266, we say yes. FAO 266 directly affects them because it subjects their vessels to mandatory installation of the VMS, as held in Calleja versus Executive Secretary. Legal standing requires a personal and substantial interest in the case, such that the party has sustained or will sustain direct injury as a result of the governmental act being challenged. Once BIFAR installs the VMS, it will have unrestricted power to access sensitive information to monitor the location and activities of the fishing vessels. This violates the commercial fishing operators' constitutional rights to privacy and against unlawful searches, among others. On the third procedural issue, we submit that the Republic's petition before the Honorable Court presents no compelling transcendental importance that justifies direct resort to the highest court and disregard of the doctrine of hierarchy of courts. The Republic argued that the EU set a deadline for the VMS installation, or else another yellow card or red card warning may be issued. But the EU communications do not provide any urgent warning, and the Republic failed to produce any letter or document to support its claim of a deadline from the EU to justify its claim of urgency. On whether the trial court acted with grave abuse of discretion in issuing the writ of preliminary injunction to enjoin the enforcement of FAO 266, we submit that the June 1, 2021 RTC decision that made the injunction permanent after a full-blown trial on the merits effectively rendered this issue moot and academic. Peña Francia Sugar Mill, Inc. versus Sugar Regulatory Administration held that a case or issue is considered moot and academic when it ceases to present a justiciable controversy by virtue of supervening events, so that an adjudication of the case or declaration on the issue would be of no practical value or use. Citing Rule 2, Section 10 of RPEC, the Republic questioned the trial court's authority to issue the injunctive writ. However, the prohibition limited itself to injunctive writs against lawful actions of government agencies, hence not absolute. The failure alone of FAO 266 to comply with Section 65.2 of the Fisheries Code IRR that requires the conduct of scientific studies in all affected regions with the participation of stakeholders clearly shows how FAO 266 unlawfulness. Now, a question arose as to what governs the issuance of writs of preliminary injunction in environmental cases. Is it the RPEC or is it the relevant provisions of RA 8550 as amended? Your Honors, we humbly submit that as a general rule in environmental cases, it should be the RPEC. But in this specific case that deals with fishery issues, RA 8550 as amended should govern. Section 134 of the Fisheries Code expressly allows the issuance of a TRO and preliminary injunction by municipal trial courts, regional trial courts, provided it is not ex parte. Before the trial court issued the writ of preliminary injunctions, BIFAR, DA, and NTC, all represented by the OSG, actively participated and presented their witnesses to oppose private respondents' application for a writ of preliminary injunction. The OSG likewise exhaustively cross-examined private respondents' witnesses. Section 134 of the Fisheries Code took effect in 2015, 5 years after the effectivity of RPEC in 2010. So, in case of conflict, the later enactment must prevail, it being the more recent expression of legislative will. On whether the RTC correctly appreciated the elements for the issuance of the writ of preliminary injunction, we say yes. For the first requisite, the clear and unmistakable right that must be protected refer to the constitutional rights of the respondents. And second, at the time the trial court granted the writ of preliminary injunction, there existed the urgent need to prevent serious damage to private respondents' right to privacy, including the protection of trade secrets against the continuous real-time monitoring, gathering, and storing of sensitive information via the VMS. On the petition filed by Oceana et al., the RTC did not err in denying their motion to intervene. Oceana et al. Have no material interest in the subject matter of litigation. Real parties in interest means those who stand to be benefited or injured by the judgment in the suit. The ruling in Ang versus Pacunio states, interest within the meaning of the rules of court means material interest or an interest in issue to be affected by the decree or judgment of the case, as distinguished from mere curiosity about the question involved. The citizen suit under the RPEC does not also apply to Oceana et al. Citizen suit as defined in Section 5, Rule 2 of the RPEC refers to an action to enforce rights or obligations under environmental laws. While this provision authorizes Filipino citizens to file a case for the enforcement of environmental laws, it does not authorize him or her to intervene in whatever case, environmental or otherwise, unless he or she has material interest to the issues. The legal issues in the declaratory relief case go beyond the scope of a citizen suit. As to the claim that municipal fisher folks have suffered the consequences of unabated and unregulated overfishing by commercial fishing vessels in municipal waters, this does not give petitioners Rosales and Reyes, with due respect, supposed fisher folks, the legal standing to participate in the petition before the RTC. The constitutional and legal issues have nothing to do with them and their fishing activities. In any case, Oceana et al. Did not avail of the proper remedy when they directly filed with the Honorable Court a petition for review on certiorari under Rule 45 to question the trial court's denial of their motion to intervene. The trial court rendered the order in the exercise of its original jurisdiction. Hence, the remedy should be the ordinary appeal to the Court of Appeals pursuant to Rule 41. Oceana et al. Directly appealed before this honorable court, supposedly raising pure questions of law, but their petitions show otherwise, with lots of questions of fact. On the first substantial issue, we maintain that FAO 266 violates the constitutional right to privacy. Section 119, in relation to Section 14 of the Fisheries Code, prescribes the imposition of the vessel monitoring measures to be promulgated by the DA. The DA and BIFAR then issued FAO 266 that requires the installation of VMS to all commercial fishing vessels as a prerequisite for registration or license renewal. Section 4 of FAO 266 provides that ERS shall be used to record and report catch data for all vessels subject to the vessel monitoring measures and lists the minimum information to be provided to BIFAR, such as the position of the vessel where they caught the fish, date and time, species and volume of fish caught, among others. However, this information to be recorded and reported, undisputably sensitive, form part of private respondents' properties as trade secrets and proprietary information. Mr. Roland Jeronimo, the Republic's witness, described this information as confidential and part of fishers' secret. Knowledge and mastery of fishing grounds, where to catch the abundant fish, make these sensitive information valuable trade secrets. Commercial fishing operators exert so much effort to prevent its disclosure. In fact, commercial fishing operators, like here in respondents, use codes in their communications. When their vessels navigate towards the fishing ground or during their regular contacts, radio operators use codes to communicate, to keep secret from other fishing companies where they will head to, or if they caught any fish. Some even go to the extent of making decoys. This creates a strategic delay against competitors and prevent them from immediately knowing the whereabouts of a bountiful catch. This special knowledge and skill, along with all the sensitive information, form part of a fishing company's priceless intellectual properties entitled to protection and privilege. Their exposure to unwarranted observation and prejudicial disclosure will result in irreparable injury. Knowledge and mastery. Perhaps we may illustrate the importance with an old familiar story. A fisherman and his group fished all night, but got nothing. In the morning, the fisherman, so tired after a night of fruitless work, was told, "Put out into the deep and let down your nets for a catch." And when they had done so, they caught so many fish, and as their nets were breaking, they asked their partners in the other boat to come and help them. While this story does not provide a binding authority, it gives us a meaningful glimpse of an important aspect of fishing, knowing and mastering where to fish. Certainly, the real-time and continuous recording and reporting of trade secrets and sensitive information violate the right to privacy of herein respondents, which in itself causes irreparable damage. The right got further violated after Petitioner Republic's witness, Mr. Demoos, admitted before the trial court that a foreign private provider of the VMS and ERS can access this sensitive confidential information. And furthermore, the VMS operator admitted that she and eight other VMS operators, the one who handled this sensitive confidential information, worked as private individuals who did not have any confidentiality or non-disclosure agreement with BIFAR. FAO 266 likewise violates the constitutional right against unlawful searches. Section 19 requires that all ALC and ERS devices or VMS shall be turned on at all times. VMS uses the GPS technology that provides real-time location of the fishing vessel. This means BIFAR will know round the clock the location of all commercial catcher fishing vessels, tantamount to an illegal surveillance. Imagine it to be like the sword of Damocles, hanging over the heads of commercial fishing operators. This brings about the chilling effect. Especially the Section 23 of FAO 266 authorizes the disclosure of sensitive technical information as evidence for the prosecution of fishery or other offenses. Petitioner Republic's witnesses admitted that the VMS seeks to instill psychological fear among fishing operators, as per the testimony of Mr. Geronimo, which I quote, "There is also a psychological effect when you know that someone is watching your move. It is quite common knowledge that compliance increases when there is regular monitoring for it." Close quote. The monitoring mandated by FAO 266 unfairly presupposes commercial fishing operators as violators that must be surveilled all the time. This already is a search, which under Section 2, Article 3 of the Constitution, only a judge upon probable cause can authorize. Petitioner Republic's unreasonable and unlawful search via the VMS not only encroaches judicial power but directly violates constitutional limitations. The search happens continuously for that matter, even before any violation and even without prior determination of probable cause. In U.S. versus Jones, a 2012 case, it was held that the government's use of an attached GPS device in a vehicle to monitor that vehicle's movements constitute a search violative of the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures, and it considered vehicle as an effect. In Dicini versus Secretary of Justice, this honorable court declared void and unconstitutional Section 12 of RA 10175 that allows law enforcement authorities to collect or record by technical or electronic means traffic data in real time. The data transmitted by the VMS fall under the definition of traffic data or non-content data in RA 10175, the Cybercrime Prevention Act of 2012. Hence, the real-time collection and monitoring of traffic data required under FAO 266 contravenes the ruling in Dicini. The Republic argued that in applying for a fishing vessel license, respondents in the exercise of the privilege to fish agreed to comply and be subjected to valid existing and future fishery rules and regulations. But, as correctly ruled by the trial court, the issue precisely refers to the validity of FAO 266, not the licenses. Moreover, FAO 266 violated the Equal Protection Clause by limiting its coverage to commercial catch-share fishing vessels only, excluding the huge number of municipal fishing boats. Considering that the VMS aims to enhance the monitoring of fishing operation, why exclude a vast sector that can provide richer source of data? Petitioner Republic tried to justify this by saying that the local governments have jurisdiction over the municipal fishing vessels, but Sections 14 and 119 authorizes the DA, not the LGUs, to establish the VMM on municipal, commercial, or distant water fishing vessels. FAO 266 also exceeded the bounds provided under Section 14 of the Fisheries Code. The latter did not state that the monitoring, control, and surveillance must be done continuously and in real time. The issuance of FAO 266 violated the constitutional right to due process and to participate in decision-making processes. Rule 65.2 requires the conduct of scientific studies in all affected regions with the participation of stakeholders who may nominate their own scientists in the formulation of DABFAR rules and regulations. This provision strongly recognizes the guarantee to participate in the government's decision-making process as contained under Section 16, Article 13 of the Constitution. But during trial, the Republic's witness admitted its non-compliance. Attorney Benjamin Felipe Estabios Jr. acknowledged that Rule 65.2 prescribes that rules and regulations to be formulated must be based on scientific studies. However, he admitted that BIFAR did not conduct any prior to the issuance of FAO 266. To show compliance, Attorney Tabios claimed the 2006 UN report as the scientific basis in the formulation of FAO 266. Although Attorney Tabios already admitted that BIFAR never presented this report to the stakeholders, being a foreign document just downloaded from a website issued without the participation of the Philippine government or any of its agencies, including the DA and BIFAR, or any Filipino stakeholders, the 2006 UN report could not be the scientific basis required in Rule 65.2. This admitted violation negates the repeated and convenient claim of presumption of regularity, with basic requisites admittedly disrespected and disregarded. No such presumption should be enjoyed. Petitioner Republic wants this honorable court to believe that it complied with the requirements of due process and public participation when it supposedly conducted consultations from November 2019 to January 2020. In reality, BIFAR did nothing but meaningless ceremonies, again in complete disrespect and disregard of 65.2. After Republic's witness, Mr. Marlo De Moos, admitted that BIFAR already acquired the VMS transceivers before the supposed public consultations and before the issuance of FAO 266. Their other witness, Mr. Jefferson de la Cruz, a fishing vessel owner and operator, confirmed that BIFAR installed a VMS transceiver on his vessel long before the issuance of FAO 266. On whether FAO 266 can be implemented without the delineation of municipal waters, we say no. Its implementation will only cause confusion and baseless apprehensions due to lack and conflicting boundary information. As of the issuance of FAO 266, all municipal waters have not yet been delineated. So unless and until all municipal waters be delineated and after NAMRIA issues the official maps, the enforcement of FAO 266, at least in relation to Section 86, will lack basis and be premature. On whether the Director General for Maritime Affairs and Fisheries of the European Commission mandated the Philippines' utilization of VMS, we emphasize that the Republic did not present any documentary evidence to prove this claim. This requires the need of factual determination to know the veracity of the alleged mandate. Lastly, Your Honors, please, on whether the declaration by the trial court of FAO's unconstitutionality contravenes the state's obligation under pertinent international covenant, such as the Convention on the Conservation and Management of Highly Migratory Fish Stocks in the Western and Central Pacific Ocean, we submit it did not. The convention concerns only highly migratory fish stocks, or the tuna species listed in Annex 1 of the UNCLOS, and not those classified as small pelagic fish that herein respondent commercial fishermen catch. Interestingly, WCPFC did not accredit SRT Marine to be among its VMS service providers. Ironically, the Republic wanted to honor its supposed international commitments to WCPFC, among others, yet WCPFC does not recognize SRT, DA's BIFAR's VMS service provider, as accredited. Your Honors, IUUF happens in many forms, like dynamite fishing, cyanide fishing, and will still continue even if FAO, assuming even if FAO 266 be implemented. It is not the magic cure that the petitioners make it out to be. With this discussion, Your Honor, please, we respectfully pray for the denial of their petitions. Thank you, Your Honors, for your attention. May it please the Court.
So let us proceed to the interpellation. May I request Justice Monet Singh to proceed with the interpellation, please.
Thank you, Chief Justice. With your permission and the courts, I'd like to start with the Solicitor General. In the interest of time, Mr. Solicitor General, you can stay in your place. You have a microphone. So first, on the procedural issues, you maintain that the declaratory relief petition before the RTC was improperly brought.
Yes,
Yes, and you question the ripeness of the issue for adjudication, at least before the RTC in Malabon.
That was done before the trial court, Your Honor.
Yes.
But, of course, during the proceedings this afternoon, I'd like to add something by way of opposing the propriety of the petition for declaratory relief.
Okay, so that settles that issue for all of us already.
I haven't said my additional argument against the petition for declaratory relief. At the time, Your Honors, that the petition for declaratory relief was filed in December of 2020, FAO 266 is already or was already being implemented. In other words, as a matter of fact, the private respondent itself, based on our information, had actually applied for installation of the VMS for its vessels. So that happened even, I think, before the time that the petition for declaratory relief was filed. So to that extent, a breach had already occurred. And for that reason, Rule 63 on petitions for declaratory relief would not be proper anymore. And instead, a petition for certiorari or prohibition should have been the proper remedy to challenge the validity or constitutionality of FAO 266. Or if the breach happened, let's assume that it happened during the pendency of the proceedings before the trial court, then the action should have been converted into an ordinary action.
You are only adopting this argument now, Mr.
Yes,
Solicitor General.
Yes, Your Honor. Please forgive me for doing so. I was not the Solicitor General at the time that the petition for declaratory relief was being tried.
Okay, but you also just mentioned that you are aware that one of the respondents, at least Royal Fishing, applied for a license or applied for the installation of the VMS.
This is the information that I got, Your Honor, of course, without prejudice to their challenge to the validity of FAO 266.
All right, thank you. Now, let's go to the issue of exhaustion of administrative remedies. You are invoking Section 138 of the Fisheries Code, the notice requirement under Section 138. But Section 138 refers to class suits, and the particular section that you refer to refers to notice to the public officer or the alleged offender. It does not mention any need for a notice to the agency, the DA, or the BFAR.
Your Honor, again, although we said that during the time that the petition for declaratory relief was being tried, I just would like to add the argument that these particular orders from an administrative agency, like any other administrative issuances that may be challenged on legal or constitutional grounds, may still be brought to the attention of the administrative or executive hierarchy, because the President, after all, under the Constitution, exercises full control and supervision over all executive offices. So to that extent, Your Honor, I would like to add, in addition to that argument, the fact that within the executive department, the chief executive maintains control, full control and supervision. And therefore, if any person is aggrieved, whether the issuance is quasi-judicial, administrative, or quasi-legislative, in my opinion, Your Honor, since the President exercises full control and supervision, there is nothing that prevents any aggrieved party from approaching the hierarchy and exhausting his or its administrative remedies.
Yes. Again, a new argument, Mr. Solicitor General. Let's shift to the compliance that you filed on September 29, where you indicated that in 2021, the total value of Philippine fishery export products to Europe amounted to some $319 million US dollars. But then in the subsequent year of 2022 also, the amount even increased to 375 million US dollars. So there is an increase from 2021 to 2022. So despite the issuance of the permanent injunction by the RTC of Malabon, it would seem that the quantity of our fisheries export to the European Union has not decreased. That's correct based on your compliance.
Yes, that is correct, Your Honor.
And so can we really say that the Philippines has suffered damage significantly because of the non-enforcement of the requirements under FAO 266, considering the issuance of the injunction?
Well, Your Honor, the problem is if the Philippine government is unable to completely arm its commercial vessel fleet with the VMS before a proposed deadline, then there is a this threat, Your Honor, is not contained in any of the written submissions or in the written communications from the European Union, but has been repeatedly stated during consultations and meetings with representatives of the European Union. So we pointed out the matter of the value of our exports to the European Union, fisheries exports, Your Honor, in 2021 and 2022, only to point out the value or the amount of economic loss that we may suffer should the European Union issue a red flag or a total ban on our fisheries exports to the European Union for our failure to comply 100% with a traceability requirement in the form of a certification by the BFAR that our exports did not originate from IUUF.
Okay, thank you, Mr. Solicitor General. Now, this VMS or ERS, we are assuming, of course, that these are up to the international standards and that they are similar to what's being used also internationally under the UN Convention.
Yes,
Is
Your
that
Honor.
a safe assumption?
Yes, Your Honor.
And in what other countries are VMS, ERS required as a precondition to fishing operations? Would you know?
Your Honor, I would not be able to venture to enumerate all of these countries, but what I can say is that most of maritime countries producing fisher products are members of regional fishing management organizations and are members of international conventions, which all prescribe the adoption of MCS or monitoring, control, and surveillance mechanisms, including VMS, in their management of their fisheries industry.
Yes, we're particularly interested in the requirement of installing VMS and ERS in the vessels themselves. So if you can provide us with that kind of information when we submit our memoranda.
We will do so, Your Honor.
And then earlier it was mentioned that actually, I think it was you, Mr. Solicitor General, you said that the information that's going to be tracked and monitored under the VMS and ERS have long been required actually, and that we're just digitizing. Is that correct?
That is correct, Your Honor, because all of these fishing vessels have been reporting on log sheets manually their catch, the location of the catch, the volume, and the fishing activities when they get back to home base. So that would take a lot of time, and so many human interventions may actually happen. So the report may be highly inaccurate. So the only value added by the VMS is to make this report on real time and electronic so that the margin of human error will be minimized.
Yes, but largely we require this information also for policy making, right?
Definitely, Your Honor. It's not just to control IUUF for investigation and prosecution purposes. That's only one of the major reasons for the VMS. But more importantly, as a management tool for conservation. Because of the data that will be collected, this will form the basis for scientific research and studies for future conservation measures.
Okay, please indulge me. My understanding is that this VMS is some kind of an electronic tracking mechanism that will show real time to our authorities where a particular fishing vessel is and
That is-
other information.
That is correct, Your Honor. It is a transponder or
Yes.
a transceiver attached to the vessel. Of course, it's got to be registered first with the NTC, the
Cor-
vessel carrying it, and then by satellite, it is transmitted by the vessel operator to, or the patron, to home base, to the BFAR,
That
through
is-
the satellite system.
Okay, so this is something we require of all fishing vessels that are registered or who apply with the government for a license.
For FAO 266, Your Honor, the scope is only for Philippine flag commercial vessels doing their fishing activities in the high seas and in the exclusive economic zones of other countries where access has been given.
Okay, so please explain to me, how is it able to prevent or detect unregulated or unreported if these are precisely vessels which are not registered or licensed and they do not have these tracking devices? How does this relate to that?
Thank you, Your Honor. There are huge screens in the Fisheries Monitoring Center of the BFAR in Quezon City. And those vessels carrying the VMS device will appear as dots on this big screen. And if these dots, these are not identified, Your Honor, these are not images of vessels. There can be no, something like you will zoom in and then you will see this particular vessel. No, it's like that. What we see are merely dots on a big screen. No identification whatsoever. So these dots or representations, some look like trapezoids, some look like arrows. These are coded in terms of shape and color. So when a particular dot appears to be approaching a restricted fishing area, then an alert will be automatically set off. So that's really the purpose of that. Or those not carrying transponders but would nonetheless be detected have their own representations in terms of shape or color. So we would know whether a foreign vessel, for example, would be entering the high seas or the exclusive economic zone of our country. So those movements are detected. But any given time, these dots are essentially stationary. So these vessels are supposed to report their locations at least once every hour. So that means 24 times during the day. So that the dots will be moved from one point to another every hour, and therefore the track will be recorded. And that would be seen on the big screen of the BFAR at its monitoring center in Quezon City, Your Honor.
So basically, it's largely to detect whether a vessel, whether licensed or not, is entering protected area.
Among many functions, Your Honor. Yes.
Mhm. But then you said that they're only supposed to report once every hour, but the transponder, if that's what we call it, is on 24/7?
That's right, Your Honor. It's on 24/7, and in fact, the law makes it a criminal offense if the transponder or transceiver is disabled or switched off.
So anytime, even if there is no report every hour, anytime we can determine the location of any of these fishing vessels.
Yes, Your Honor. So that in certain areas, for example, there will be some mass gathering of dots or representations, then that would signify that so many vessels are in that particular area of the high seas.
Okay, thank you. Now, my next question is, since the issuance of FAO 266, has there been a significant improvement in the prevention or detection of IUUF? And do you have studies or data to back this up?
I think the BFAR would have that kind of information, Your Honor, and
Okay.
if that will be requested,
Yes.
then BFAR will be able to submit that.
Okay, please do so. Thank you. Now, if the transponders already tell the authorities real time where a particular vessel is, the date and the time as well, why is there still a necessity to give all the other information, like the species, the position, the species and volume of the catch, the position of the vessel where the fish was caught? Why are those things necessary to detect IUUF?
Your Honor, it's not just the location, it's also the catch. That is very important to be collected. That is why the system involves the VMS to track the location and the ERS, the electronic reporting system, so that the catch, the amount of the catch, the species of fisheries of fish which have been actually caught can be immediately transmitted to the BFAR. And that information, Your Honor, is very important, as I said, to determine traceability where this particular fishery products have been caught, and also for as a management tool to determine whether certain species are being overfished, and so forth and so on.
Now, the installation of the VMS in the vessels will disclose and record their destinations and the places where the fish operators conduct their fishing activities. However, when we speak of monitoring, it was defined under the Fisheries Code as limited to just the fishing effort, that's the number of days or hours of fishing, plus the fishing gear, the number of fisher folk, and then the characteristics of the fishery resources or the type of fish. And then third is the catch, the yield. So does this not go beyond how it was defined by the Fisheries Code, how monitoring was defined under the Fisheries Code?
Your Honor, in my opinion, the wordings of the law itself does not, the wording does not really preclude the administrative agency which is in charge of implementing that particular provision of the law to expand, if necessary, certain details so that the entire objective of the legal provision may be achieved, for as long as let's say the amendment or the modification does not radically depart from what is provided for in the statutory provision of the law.
Yes, okay. So, but we cannot expand what the law itself has set.
You know,
Yes.
but there is nothing really that the FAO 266 contains that unduly amends or unduly expands the provision of the Fisheries Code.
Okay, it's just because that in Section 14, we have a very specific definition of what monitoring covers. And yet in Section 4 of FAO 266, you have many other information that's not in Section 14. Anyway, Mr. Solicitor General, Attorney Naval earlier spoke about the lack of scientific studies and the testimony of your very own witnesses, well, at least the government witnesses before the trial court. In regard to this, I'll give you a chance to rebut that.
Your Honor, the basis of the BFAR, the scientific basis, if I may be more specific, is the report of the UN experts consultation that was held in Rome in 2006. That is a conference among experts on marine conservation, and their unanimous recommendation during that experts consultation was for all the member states to adopt a vessel monitoring system, and that includes the adoption of the VMS itself, which our BFAR dutifully followed. So if I may say, the lack of actual scientific studies conducted by the BFAR does not constitute an obstacle to adoption of the VMS, because it is based nonetheless on an international consultation of experts on VMS. So I believe that that would be sufficient legal basis, Your Honor, or
Okay.
scientific basis.
So you admit, Mr. Solicitor General, that there were no scientific studies conducted by BFAR or the DA on its own, just the UN report?
Your Honor, I am not too sure if there were no such scientific studies. The private respondents merely cited a testimony given during the trial of the case below, but I am not sure whether that is really a very accurate statement. Knowing BFAR, Your Honor, it's our fisheries expert, and it has been for many years collecting scientific data on fisheries catch. And I would find it rather unbelievable that the BFAR, which has been there for many decades, would not be doing any scientific study pertaining to conservation measures, including the possible adoption of VMS. But the representatives of the BFAR are here, and if you wish to ask them directly, Your
Well,
Honor.
actually, if you want to make that statement, you can make that statement when you submit your memorandum.
Thank you.
But I just gave you a chance to respond to the statements, the opening statements of the respondents. Now let's go to the red card. The red card from the European Union that you have been mentioning. This applies to fishing in what waters?
Commercial vessels are the vessels mentioned in the European Union communications, Your Honor, the commercial fleet. So that means to say that we are not talking about municipal vessels here. So the intention really is for all commercial vessels to be equipped with a VMS. But for now, Your Honor, FAO 266 prioritized the installation of VMS only on commercial vessels which will do their activities in the high seas and in the exclusive economic zones of adjacent countries where access has been given. It doesn't really preclude the FAO from issuing at a later time further administrative orders directing other types of vessels, commercial or municipal, from installing VMS in their units. It's just a matter of prioritizing certain vessels at this time, but the BFAR from adopting the same requirements for other types of vessels.
Yes, I asked that question, Mr. Solicitor General, because counsel for the respondents earlier stated that the respondent fishing companies do not export. Did I get that correctly? Do not export their catch. And so I wonder how the EU's concern relates to them.
Your Honor, it does not really matter to us whether the private respondents are actually exporting to the European Union. What we're after here is compliance with the FAO 266. So this regulation will affect those commercial vessels plying the high seas and the EEZs of other countries, regardless of whether they export their products abroad or simply bring in their haul for the domestic market. Doesn't really matter, Your Honor.
Yes, but you invoke the red card warning in your application for an injunction before us, Mr. Solicitor General.
Yes, Your Honor, that is correct.
Okay. So my last question for the Republic is, Are you aware if we have been issued like a yellow card or a red card by any other country or any other authority or organization by reason of this, the non-installation of VMS?
No other entity has issued any kind of warning to us except the European Union in 2014. A yellow card, a warning that was lifted the following year when Congress enacted the law against illegal, unregulated, and unreported fishing.
Okay. Thank you, Mr. Solicitor General.
Thank you, Your Honor.
Now, with the permission of the Chief Justice and the Court, I'd like to ask a question of Oceana, the counsel, Attorney De Castro. Attorney De Castro, you filed a motion to intervene before the RTC.
Yes, Your Honor.
And of course, the main action is the declaratory relief action.
Yes, Your Honor.
And the motion to intervene was an incident.
Yes, Your Honor.
So the denial of your motion to intervene, upon the denial of your motion to intervene, you filed a motion for reconsideration. It was also denied.
Yes, Your Honor.
And then you brought up the denial to the court straight.
Yes, Your Honor. Before this honorable court, yes.
Yes, via?
Via Rule 45, Your Honor.
Okay. And Rule 45 under the rules of court can be brought by whom?
Your Honor, if I may also...
No,
make-
please answer my question.
Before, by the parties themselves,
A
Your Honor.
party, by a party.
Yes, Your Honor.
By a party to the
To the case.
to
Your
the
Honor.
case.
Yes, Your Honor.
Is Oceana a party to that case before the RTC?
If I may make reference...
No, please answer my question.
Not yet, Your Honor.
Not yet, because its motion to intervene was denied.
Yes, Your Honor.
Yes, and yet you filed a Rule 45 before us.
Yes, Your Honor. If I may...
You wanted to go straight to the court?
If I may point to the appropriate case, Your Honor.
No,
The-
do not. You do not have to. You can cite that in your memorandum.
Yes, Your Honor.
I'm just going through my question so that I can be enlightened about your position. I want to understand why you chose to file a Rule 45. Okay, so we understand that a Rule 45 is part of the appeals process,
Yes, Your Honor.
and for a party to have an appeal or a right to appeal, you have to be a party to the original case.
Yes, Your Honor.
And because your motion to intervene was denied, you are not a party or were not a party to the RTC case.
We have two grounds, Your Honor, to file the Rule 45 petition, our Rule 45 petition. Considering, Your Honor, that the parties themselves, all parties before this case, have admitted the applicability of the rules of procedure for environmental cases.
I don't think that the respondents have conceded that.
It is in their position, Your Honor. Paragraph
Well,
4 of
That is for us to decide.
Yes, Your Honor.
But my only concern is that you brought a Rule 45 from the denial of your motion to intervene.
Consistent with the rules of procedure for environmental cases.
All right, thank you.
Thank you, Your Honor.
That's my only question for you. And now, with the permission of the court, I would like to ask my questions of the respondents, Attorney Naval. Your license, the license of Royal Fishing, you speak for Royal Fishing?
Yes, Your Honor.
Okay. The license for Royal Fishing expired in July of 2021, is that correct? Well, at least the license that you submitted to us, that is part of the records.
Yes, Your Honor.
So has this been renewed?
Sure. Your Honor, yes, it has been renewed, Your Honor.
Okay. And as you stated earlier, or as the Solicitor General stated earlier, there is already an application from Royal Fishing to install VMS in its fishing vessels. And in fact, some of its fishing vessels already have VMS.
Yes, Your Honor, because they made it a prerequisite for the renewal of their license.
Of the license, okay.
Yes, so we filed a reservation to that effect, Your Honor.
Okay. Are all the
All
fishing
parties.
vessels of Royal Fishing already installed with this equipment? All?
I believe all their licenses are now valid, Your Honor, because they had the VMS installed, but with reservations, Your Honor.
Okay, so even Bonanza and RBL. Because the only things we have in the record for the two of them are their permits to conduct business. We don't have copies of their license.
With respect to Bonanza and RBL, Your Honor, the BIFAR no longer required them to install the
VMS?
because of the case file.
Okay, but they have existing effective licenses.
Yes, Your Honor.
Okay. Now, you would agree with me, Attorney Naval, that for the respondents, they will be directly benefited when IUUF is significantly reduced
Yes, Your Honor.
and fishing becomes sustainable.
Yes, Your Honor.
Okay. And the installation of the VMS and the ERS, are those not reasonable safeguards or measures towards this end?
Your Honor, please, we do not think that the installation, the mandatory installation of the VMS is actually a valid measure to curb or eliminate IUUF. It's for the monitoring of the vessels, but not really to address directly IUUF, like illegal fishing, Your Honor, cyanide fishing, dynamite fishing. The VMS, it has no capacity to curb or eliminate those kinds of illegal fishing. Unreported fishing, the VMS cannot assure that what is being transmitted because the data, the information, they are still to be manually inputted in the equipment, Your Honor. So what we're saying is that it really does not directly address curbing and eliminating IUUF, but it may be for the monitoring.
Okay. Before the VMS or the ERS were required and before they were installed in your fishing vessels, were there measures already required by the BFAR and by the DA for fishing vessels, for commercial fishing vessels towards this end?
Yes, Your Honor. We have the so-called manual reporting. The data of the fish catch, the location of where they caught the fish, date and time, these are usually submitted. These are regularly submitted, actually, to the PFDA whenever the carriers come home with their catch, they report to the PFDA. And also on the renewal of their licenses, they submit logbooks or containing their catch, where they caught the fish, manually, Your Honor.
Okay, so if you were complying manually, what is your objection now that this is being required in an electronic form?
Yes, thank you, Your Honor. Because, Your Honor, the manner of fishing of hearing respondents, that's why at the onset, I tried to distinguish them, the galunggong fishing operation from tuna fishing operation. Galunggong fishing operations, Your Honor, since I recall a long time ago, they operate already on trade secrets on where to fish. Because small pelagics, the fish that the respondents catch, they are small pelagics. They float in a certain area of water. They do not migrate to other borders. So it's a challenge for fishing boat operators on galunggong fishing operation to know where they are, to know where to catch them, Your Honor. And so that's the difference. In tuna fishing, Your Honor, I mentioned there are migratory pathways. There's not much secret to know about that, Your Honor, because these pathways are already determined. Unlike in galunggong fishing operation, Your Honor, they have to determine where the abundant schools of galunggong are.
Yes, but manually you were already reporting the locations according to you before the VMS were required.
Yes.
Now the VMS is only going to do it digitally.
Yes,
So
Your
what's the
Honor.
difference? I don't see the difference. What is your objection to the digital recording as opposed to the manual, which you said you were complying with?
Yes, Your Honor, please. It's the real-time monitoring of when they will be able to catch on that particular night, how much, because that is their trade secrets already, Your Honor. When all things considered, the day of the month, and that particular time of the year where they recall that they caught that particular fish, all things taken into consideration, Your Honor, they want that as a secret at that very moment in time. Because, Your Honor, the worst thing that could happen is that they load fuel, ice, and everything, spend millions of pesos to go to that particular fishing ground and that particular spot in the fishing ground, and only to expect that there is another fishing company who discovered that that's their trade secret and was able to beat them to the draw on that particular fishing ground.
Okay, and so the real-time reporting digitally will open up the possibility to more competitors going to that site that you or your clients, develop.
Yes,
Is
Your
that your
Honor.
position?
Yes, Your Honor.
Okay, thank you. So as a last point, you of course concede that all these resources are owned by the state.
Yes, Your Honor.
And because they're all owned by the state has the right to, to regulate and to control.
Yes, Your Honor.
And in doing that, the state can issue regulations,
Yes, Your Honor.
like FAO 266.
Yes, Your Honor.
Yes, okay. All right. I have no further questions, Chief. Thank you.
May you ask Justice Scott to proceed with his interpellation?
Yeah, Chief. Thank you very much, Chief. With your permission, Chief, and with the court, I would like to ask Mr. Solicitor General a follow-up question from the question of Justice Singh. Good afternoon, Mr. Solicitor General. With respect to the VMS as well as the ERS, the BFAD came out with this regulation to install this on our fishing vessels. It gathers information. Does this VMS ERS standard worldwide? Meaning the software or the information to be gathered here, the manufacturer, are the same?
Your Honor, this is fairly standard because there is a system of accreditation that is set in place by some organizations. But by and large, globally speaking, these are fairly standard in the sense that certain minimum outputs can be gathered by the devices.
Okay, so the information to be gathered in the VMS of the Philippines, of BFAT, in comparison, let us say, with other countries, there's a basic or minimum information that it can be sourced or gathered by this VMS?
Yes, Your Honor.
Okay. Are there any information that we will gather in our VMS or ERS that are not available with respect to the other countries?
Your Honor, I am not in a position to answer that question because I have no detailed information as to the kind of data being gathered by other jurisdictions. But we can request the BFAR, if they have that information, to submit it to the court.
Okay, I would like to relate this to the requirement of the EU. When the EU requires us by virtue of treaties or agreements, are there any minimum information that they require? And what are the minimum information required before we can issue the certification?
Your Honor, based on the communications that I have seen, the European Union is basically requiring the our commercial vessels be equipped with a VMS. I am not privy if certain minimum information or data are being required. But the underlying purpose of the European Union in requiring us to comply with the vessel management, vessel monitoring measures or systems is to ensure traceability of the catch. In other words, a certification from our BFAR that the catch was not through any IUUF methods. So if that is the case, Your Honor, I presume that information on where, what, and how these fisheries products were caught would be definitely included in the information being requested.
Okay, I would like to zero in on the main objection of respondent on the real-time information. Based on our VMS or ERS, the vessel will have to would have to disclose on real time their location, their catch, etc. Is this a specific requirement from the EU? A real-time information gathering from our commercial vessels?
There is no specific requirement from the European Union regarding that. All it wants is an assurance, a certification from the BFAR that the fishery products that we are exporting to them are not sourced from IUUF. And for that reason, they are very much aware that we have not completely complied with, or vessels rather, have not completely complied with FAO 266, and that's what they're monitoring. They're looking for a 100% compliance with FAO 266.
So therefore, Mr. Solicitor General, even if our commercial vessels would not, or even if the VMS or ERS would not require a real-time reporting or gathering of information, you are telling the court that we are still would be in compliance with the requirements of the EU.
That is correct, Your Honor, except that from the point of view of the BFAR, the use of the VMS is the most cost-effective and most efficient. Because what is our alternative if you are not going to use real-time VMS? The alternative is for BFAR patrol vessels to actually be out in the high seas and determine what these commercial vessels are doing out there. That is simply, in terms of logistics, there are only, I think, something like 18 patrol vessels of the BFAR, which are capable of going to the EEZ and the high seas. So it is almost impossible to use an alternative way of monitoring the location of vessels. And this provision of a satellite-based monitoring device seems to be the most cost-effective and efficient way of doing it. Almost real-time, not exactly real-time, Your Honor, but near real-time, rather than the manual accomplishment of log sheets upon return to home port, which will probably take months, weeks, if not months, when the vessel, catcher vessel, actually returns to port. That's the only time that they will submit the manually accomplished report of their catch, their location, etc., etc. We can immediately see the great advantage of having this kind of electronic system compared to a manual system that will be accomplished in weeks, if not months, after fishing out in the high seas. The catcher vessels, in my understanding, based on what the BFAR told me, would stay on the high seas for at least 8 to 9 months before returning to port. Your Honor.
Thank you, Mr. Solicitor General. Can I ask a question for counsel for respondent? Now, Section 2 of Article 12 of the Constitution provides that all waters, fisheries, and other natural resources are owned by the state, which shall not be alienated. Section 2 further provides that the exploration, development, and utilization of natural resources shall be under the full control and supervision of the state. The concept of control has been defined as referring to such degree as sufficient to enable the state to direct, restrain, regulate, and govern the affairs, which may include the establishment of policies, guidelines, regulations, and similar measures that would enable the government to regulate the conduct of affairs and restrain activities deemed not desirable or beneficial, with the end in view of ensuring contribution to the economic development and general welfare of the country, conservation of the environment, and uplifting the well-being of the local affected communities. Now, Council, you agree with me that based on these provisions, the state has the power to direct, restrain, regulate, and govern the utilization of Philippine waters, which include the EEZ as defined under the Philippine Fishery Code.
Your Honor,
Yes or no?
Yes, I agree,
Yes.
Your Honor.
Okay. Now, do you agree with me that fishing, whether for private or commercial purposes, on Philippine waters, constitute utilization of waters, fisheries, and natural resources, and hence subject to state control and supervision or the state power to direct, restrain, regulate, and govern? Yes or no?
Yes, Your Honor.
Yes. Now, can any part of the Philippine waters be subject to private ownership?
No, Your Honor.
No. Okay. How about control or any part or portion of the Philippine waters to the exclusion of other persons? Meaning, as a follow-up, can any person prevent another person from going to the same location or area of the Philippine waters where the former is at?
No, Your Honor.
No. Can any Philippine citizen, whether natural or juridical, utilize, access, or traverse any part or portion of Philippine waters? Can any person or any Filipino citizen, whether natural or juridical, utilize, access, or traverse any part or portion of Philippine waters? So anybody.
No, Your Honor.
You cannot, this is not available to anyone?
Provided they are
Filipino
they-
citizen?
Provided they are licensed to do so, Your Honor.
Yes. Okay. Now, let us go to the issue of searches and seizures. Our Constitution and jurisprudence recognizes zones of privacy. Now, it has two. Number one, the right to be alone or the right to be secure in one person's house, papers, and effects against unreasonable searches and seizures. And number two, the right to privacy of communication and correspondence. Within these zones, any form of intrusion is impermissible unless excused by law. Now, does the information respecting the location or position of a vessel in Philippine waters that would be disclosed in this VMS constitute persons, houses, papers, and effects, or communication or correspondence?
Yes, Your Honor. Effects, Your Honor.
What do you mean by that?
These information are proprietary information and trade secrets of the commercial fishing operators, meaning they have informational privacy with respect to these informations, Your Honor.
Okay. Now, the requirement to give information respecting the location of your vessel constitute search or seizure? You're giving information. Would that constitute search or seizure?
Search. Unlawful search, Your Honor.
Why would that be considered as an unlawful search or seizure?
Because, Your Honor, they are already tracking the activities of the fishing vessels real time. real time, Your Honor, even without without even a violation, Your Honor. In the case of U.S. versus Jones, Your Honor, it was held that the attachment and the use of the GPS, no, to monitor the vehicle is a search. It is a warrantless search, Your Honor. So in this case, the installation of a VMS, considering that the vessel is also an effect of contemplated under the Constitution on rights against to be secured on your effects, the vessel, Your Honor, it has the right. It has the right, Your Honor, to be secured in its.
Okay. Now, with respect to your so-called trade secrets, is there a reasonable expectation of privacy in public places or public spaces?
In public.
Philippine waters.
Okay.
You agree with me? The Philippine waters is considered a public space.
Yes, Your Honor.
Okay. Is there a reasonable expectation on your part of privacy in Philippine waters?
Yes, Your Honor.
Why do you say that?
Because, Your Honor, the conduct exhibited by the commercial fishing boat operators, it exhibits expectation of privacy by practicing using of codes, not revealing this information, Your Honor. And the society recognizes this practice as reasonable. In fact, in the legislation, Your Honor, they consider this information as sensitive information, Your Honor.
Yes. Now, when you say the state recognizes that expectation of privacy, what is your basis? Would the state automatically agree that you have an expectation of privacy in Philippine waters? Are you saying that the state should recognize?
Yes, Your Honor. Yes, Your Honor.
Who has the burden of proof to show expectation of privacy in Philippine waters?
Your Honor, please. We believe, Your Honor, that the commercial fishing boat operators are entitled to their trade secrets and for it to be protected and be privileged. Now, they can invoke that, Your Honor, against intrusions of the government, them having such informational privacy and complying with the test on whether there is privacy, Your Honor.
But you earlier said that as long as the vessel is registered, anybody can utilize Philippine waters to gather fish.
Yes,
So why would you expect some kind of privacy or trade secret on an area that you have done fishing and exclude any other person from beneficial use of that Philippine waters?
Because, Your Honor, those informational privacy, they are closely intertwined with the trade secrets of the respondents, Your Honor, of the commercial fishing operators. That's why.
Okay. Basically, what you're saying now, central to your argument is the so-called trade secret.
Yes, Your Honor.
Can you define what is trade secret and what legal basis do you have to invoke trade secrets in this case?
Okay. Your Honor, trade secret of the respondents, it refers to the secrecy in how to get to that fishing ground, knowing where the exact location of the abundant fish, Your Honor. They have to determine when they should go there, the time that they should go there, Your Honor. So it's not the fishing ground itself per se, but taking all these things in consideration. Like I mentioned before, where exactly and when did you last go to that fishing ground? Do you think that the spotting there has already started? Do
No,
you think-
Counsel,
Yeah, yeah.
what I'm trying to drive at is that you're saying this is your trade secret.
Yes, Your
And
Honor.
you are prohibiting anyone from knowing it.
Yes, Your Honor.
Okay. What is your legal basis in saying that this is, number one, a trade secret, and number two, you are not, the other person are not allowed, are not supposed to know of this trade secret?
Your Honor, it's by the conduct of the company.
Would you consider trade secret a property right?
It's a property right, Your
Why
Honor.
do you say it's a property right?
Because, Your Honor, this information have been gathered by these respondents through years of learning and experience and gathering of all this historical data. Now, as such, these trade secrets become protected and privileged, Your Honor.
Okay. Earlier, you mentioned about possible leakages or information that might leak out with respect to these VMS. Now, earlier you said that foreign private providers are already in, and you're questioning this. Now, are these related merely to the enforcement of FAO 266 or to the nullity itself of the FAO?
To the nullity, Your Honor.
Why would you say that? If just merely securing a foreign private provider. So if it's a local provider, there would be no issue on your part.
Well, Your Honor, our issue really is the extracting of the information, whether it's a local provider or a foreign
So therefore,
provider.
with the ground you earlier raised with respect to this private, foreign private provider merely relates to the enforcement of the FAO. It's a question FAO. Not as to the illegality, alleged illegality of FAO 266.
Yes, Your Honor.
Okay, thank you for that. Now, under RA 8550, there's a provision there that provides for imprisonment of unauthorized disclosure of sensitive information or data covered by the VMS. Would this not be sufficient to address your concerns?
No, Your Honor.
Why?
Because all those provisions in the law prescribing a penalty already presupposes that there has been a breach, Your Honor. So the concern really is how to secure. That's the problem. We do not agree that any action will give comfort to the owners of this information that it is secured, Your Honor.
So, am I correct to say that the fear that you have right now is basically speculative?
No, Your Honor, it's not speculative. In fact,
Because, in fact, is there already a violation, an information on your part that BFAD already disclosed any confidential information to other fishing vessels that at the time you were there in an area that you found to be rich of fishery products, another vessel came in? Do you have that information, or do you receive that information already?
not at the moment, Your Honor. If I
So,
may.
so therefore, basically, this is speculative.
No, Your Honor. Because they already have access, Your Honor. So it means it's already intruding into the trade secrets of our client, Your Honor. So the fact that there are those handling this VMS, they have access of the information. The fact that foreign service provider can have access, the information is already being spread, Your Honor. It's going out already.
Okay.
So that's our concern.
Now, can you, this commercial fishing vessel license, can you tell us what is this?
Your Honor, it's their license given to commercial fishing boat operators to fish within Philippine waters.
So I presume all your vessels would have a license.
Yes, Your Honor.
Okay. Now, to obtain this license, you have to comply with certain requirements, right?
Yes, Your Honor.
And one of these requirements is what is known as the grid map indicating the proposed fishing grounds.
Yes, Your Honor.
Can you tell us what is this grid map? Yeah, you may consult your client on this.
Okay. Thank you. Your Honor, please. That requirement is being imposed against the applicant to show, for them to show to the BIFAR where they intend to fish.
Yes. So therefore, part of the requirement of the license is that for the applicant to provide a map where they intend to fish.
Yes, Your Honor.
Okay. So therefore, once the license is given, an area is basically identified for the fishing companies where they could fish.
Yes, Your Honor.
Okay. Now, my question is, once a license is given for a particular grid map for the fishing companies, is this exclusive for that fishing vessel or fishing company?
No, Your Honor.
No. So therefore, any other fishing vessel or company can still fish in that grid map.
Yes, Your Honor.
Okay.
Yes.
Now, one of the requirements for compliance or grounds for cancellation or revocation of the license is non-compliance with the terms and conditions of the license, which includes fishing outside the area specified in the license. Do you agree?
Yes, Your Honor.
Okay. Now, since the submission of the grid map is part of the requirement for the issuance of the license, the information or data to be obtained from the VMS ERC regarding the location or position where the license will be conducting fishing activities at any given time is effectively pre-disclosed to the BIFAR such that it is no longer constitute confidential information. Since you already disclosed through the grid map your location, so therefore, requiring it through the VMS would no longer constitute confidential information, Counsel.
We beg to disagree, Your Honor. The map being submitted there is so vast, Your Honor, because they have to have a choice. No? They have to have a wide fishing ground for them to determine, and those are the fishing grounds that they would most likely be able to fish. But the exact location of where the fish will be found at a particular given time is not revealed to the BIFAR.
Okay, now, this installation of the VMS is essentially to ensure that the one who has a license to conduct their fishing activities within the approved grid map, right? And would you agree with me that the reason why this VMS was required is for effective management of fishing resources to deter or curtail illegal, unregulated, and unreported fishing? That would be an effective tool, not only for, as you said, dynamite fishing, cyanide fishing, but all other violations or that would be illegal, unregulated, and unreported fishing.
No, Your Honor. The primary purpose for the VMS, as stated in the conventions, therefore highly migratory fish stocks, Your Honor, for tuna, not for the small pelagics where what that is being caught by the respondents, Your Honor. Highly migratory fishes. The reason why, as I mentioned a while ago, this is being strictly monitored because the stock can be caught in one country, transported to another country, transshipped, exported to another country, and processed in a fourth country. So that's why they want to to monitor those tuna species, Your Honor.
So
Not the
are
same.
you suggesting to BFAD that there is a substantial distinction between tuna fishing as well as galunggong fishing?
Yes, Your Honor.
So therefore, but all of these are commercial vessels.
Yes, Your Honor.
How could you implement a effective monitoring system when you yourselves gather fishes in the same area outside municipal waters?
If I may, Your Honor, there is actually an FAO already in place, 260. This addresses the installation of vessel monitoring system to Philippine fishing vessels who engages in highly migratory fishing, or they catch tuna. It's already in place, Your Honor. Now, that's FAO 260. However, in FAO 266, they already disregarded the primary purpose why the conventions are requiring, Your Honor, the installation of VMS. They included even the small pelagic. And these are not actually, Your Honor, the concern of the conventions being mentioned, Your Honor. They focused only, if you will check, Your Honor, please, highly migratory stocks. These species are actually the tuna family, Your Honor.
So you're saying there is a substantial distinction, but is that part of your argument in your petition?
Well, Your Honor,
I haven't read that argument in your petition.
in the lower court, Your Honor, that was not the issue. They never raised those issues, Your Honor, only here, Your Honor. But we can include that in the memorandum if...
Thank you, Chief.
Thank you, Your Honor.
Thank you, Justice Ko. May I ask Justice Dimampao to proceed with his interpellation?
Thank you, Chief. I have only a few questions for the petitioner and respondents. Let me start with my questions for the petitioner. May I ask the Solicitor General, Minardo Guevara, to answer these questions?
Good afternoon, Your Honor.
Good afternoon. Mr. Solicitor, you must be cognizant of or familiar with the text of Fisheries Administrative Order 266. Right?
Yes, Your Honor. I have read it.
It has 5 chapters consisting of 26 sections, correct?
I think so, Your Honor.
FAO 266 mandated the installation of vessel monitoring measures on all commercial catcher fishing vessels operating in Philippine waters and all vessels in distant waters, correct?
More particularly, Your Honor, in the high seas and in the exclusive economic zones of other countries where access is authorized.
What is the statutory basis for this requirement?
Your Honor, the legal basis for the FAO 266 is found in Section 14 and Section 119 of the Fisheries Code as amended by the IUUF law. Section 14 mandates, Your Honor, the establishment of a monitoring, control, and surveillance system. And Section 109 states that no person may conduct municipal or distant water or high seas fishing without the proper vessel monitoring system as prescribed by the Department of Agriculture through the BFAR.
You must be referring to the 1998 Fisheries Code, Republic Act 8550 as amended by Republic Act 10654.
Yes, Your Honor.
Aside from this, WOW 266, did this WOW 226 make any reference to any convention, treaty, or international covenant relative to this requirement?
I am not sure whether there are exact provisions in FAO 266 which make reference to our commitments under international conventions or regional fisheries management organizations, Your Honor. But
There is,
yes,
in whereas paragraph 3,
in the whereas
mention
clauses, Your Honor.
of this convention
Okay.
on the conservation and management of highly migratory fish stocks in the Western and Central Pacific Ocean.
Thank you, Your Honor.
It's not in these chapters or sections. It is there in whereas
Whereas
paragraph.
clauses.
It is mentioned. Is the Philippines a signatory to this convention?
Yes, Your Honor. As a matter of fact, our membership or accession to that international convention was ratified by the Philippine Senate
When?
in
Was it?
2005, if I'm not
2005.
mistaken.
And the Philippines signed that convention on September
Your Honor,
5.
I think in 2004,
2000. September 5, 2000.
right, and subsequently ratified by the Senate.
In 2005.
Yes, Your Honor.
In that convention, are you aware of the duties of the state party?
Yes, Your Honor. Some of the more important duties of state parties would be to establish systems of monitoring, control, and surveillance so that the management of fisheries, their conservation, will be promoted.
Have you read Articles 23, 24, as these particular articles of the convention made mention of the duties of the state party there too?
Your Honor, I must have passed over those particular provisions when I read the convention a number of days ago. I think so, I did.
I
think I did.
that you have read the convention.
Yes,
Have
Your
you
Honor.
come across that commission mentioned therein that is tasked to monitor compliance with this?
Yes, Your Honor.
monitoring.
Yes, Your
What is
Honor.
that
I
commission?
just wouldn't remember the section number or the article number, Your Honor, but I distinctly remember that it is stated as one of the state duties.
Western and Central Pacific Fisheries Commission.
Yes, Your Honor.
There are guidelines laid down by this commission regarding the installation of vessel monitoring measures, correct?
Yes, Your Honor.
Let me lead you. If you refer to the website of this commission, it invariably laid down guidelines starting in 2008 to 2022. My question now is, have you come across these guidelines set forth or prescribed by this commission on the installation of these vessel monitoring system.
I'm sorry, Your Honor, I wasn't able to look at the guidelines on the website of the convention. I was not able.
Okay, with all humility, there are three. One, which was effective on February 6, 2012. That is entitled Statement of Purpose and Principles regarding this VMS. The other one, which it was first approved on February 12, 2010, and updated on February 8, 2022. It is entitled Standard Operating Procedures regarding this VMS. And the third one, which was first approved on in December 2008 and updated in December 2021. It is entitled Specifications, Procedures, Standards. So there are guidelines on these installation of the VMS. Have these, to your knowledge, Commission standards been introduced in local legislation?
In local legislation, I am not aware of any, Your Honor, but administrative issuances of the BFAR may have incorporated certain provisions of these guidelines so that the minimum standards for the VMS devices would be met. After all, we are a state party to the convention, and we have adopted that convention as part of the law of the land because it was ratified by the Senate. So it is my humble submission, Your Honor, that these guidelines were observed by the Department of Agriculture and the BFAR when it contemplated on the issuance of FAO 266.
Okay, can you mention this in your memorandum just for the guidance of the court?
Yes, Your Honor, we'll do so.
Apart from Fisheries Administrative Order 266, what are other measures adopted by the Philippine government designed to ensure compliance with these vessel monitoring measures?
Your Honor, I mentioned much earlier the matter of manual reporting, but that has since been abandoned because of our adoption of this electronic, almost real-time system of reporting. There are other measures that may be adopted, but they are not very cost-effective. For example, the matter of allowing inspectors to board actual commercial vessels, or the matter of sending out our own BFAR patrol vessels to monitor actual fishing activities. These are alternative ways, Your Honor, but you can realize probably how inefficient these other measures would be in comparison with the electronic VMS system.
Well, what will be the repercussions should the Philippine government fail to comply with such requirement under that convention?
Your Honor, it is possible that if we consistently fail to comply with the provisions of this convention, we may not be allowed to fish in certain areas that have been, where access had been previously given. So if it becomes, a matter of consistent failure on our part to honor our international obligations, it is possible that we may lose access to certain fishing grounds where before we had been given such authorization.
These are found in Article 25 of the Convention.
Thank
The
you, Your Honor.
consequences.
Thank you, Your Honor.
Has the Philippine government received any formal communication from the convention, from the commission that I have said it a while ago about compliance with these requirement prescribed under that convention, if you know?
None that I know of, Your Honor. We have not received any such warning or notice that we are not complying with our obligations under the convention. Of course, the European Union gave us that kind of notice, but it's not a member, I think, of that convention, because that's only for the Central and Western Pacific region.
Are you telling us that the Philippine government has never been sanctioned for such failure or alleged failure to comply, to abide by its duties under the convention?
So far, my information is we have not been sanctioned by any regional group for alleged failure to comply with our obligations thereunder.
I attentively listened to your opening statement. You made mention a lot of international covenants that are consistent with this requirement on the installation of vessel monitoring measures. Are there international covenants or conventions aside from what you have mentioned that also adhere to this requirement on the installation of vessel monitoring measures?
There must be some regional fisheries management organizations, Your Honor, of which we are not a member. But my understanding is that vessel monitoring measures are fairly standard globally, so that in other conventions, in other parts or other regions of the world, I am pretty sure, Your Honor, that such a requirement is also being imposed. But we can submit, Your Honor, a list of such other conventions or international agreements, aside from those that I enumerated, where a vessel monitoring system is also being required.
Are you not familiar with this 1995 UN Fish Stocks Agreement?
I have read about the 1995 UN Fish Stocks Agreement. Your Honor.
But you have not mentioned that in your opening statement.
Sorry about that, Your Honor. It's not meant to
Have
be.
you read this 1974 International Convention for the Safety of Life at Sea, or SOLAS?
No, Your Honor, I was not able to read that.
That's why you have not mentioned that in your opening statement. Thank you, Mr. Solicitor General, for the, thank you.
Thank you, Your Honor.
For the respondents, I have only 4 questions. Fisheries Administrative Order 266 declares that the rules and regulations contained therein were promulgated in consultation with National Fisheries and Aquatic Resources Management Council.
Yes,
Is
Your Honor.
that correct? This in-farm has a core function. What is the core function of this?
Essentially, you can derive it from their name, NFARMC, National Fisheries and Aquatic Resource Management Council. They formulate policies, they study policies to be recommended for the approval of the department secretary.
And that council represents 6 sectors in our society. Do you know these 6 sectors in our society represented in that council?
I will try, Your Honor.
Commercial fishers, that's one.
That's one. Yes, Your Honor.
Or you are represented in that.
Yes, Your Honor.
Municipal fisher folk,
Yes, Your Honor.
aquaculture, fish processing subsector, academe, and NGO. Those are the 6. So you are one of them. Upon the promulgation of this POW 266, were you not members of this council?
There is a representative of the commercial fishing sector, Your Honor. But when they formulate, of course they have to agree, and some of the members do not agree on the formulation of that, but they cannot do anything because it's a majority decision, Your Honor.
So you were heard in that, in the proceedings before it.
The representative of the commercial fishing sector.
So you were clearly represented in that council.
Yes, Your Honor.
That will be all. Thank you.
Thank you, Your Honor.
Thank you, Chief.
To Justice Dimampao, may I call Justice Jolo Lopez for his interpellation? 10 minutes.
Can I call on Attorney Nabal?
Yes, Your Honor.
How are you, Attorney Nabal? Are you okay? Take a deep breath.
Thank you, Your Honor.
Anyway, these are only few questions that I will ask. And these are follow-up questions to those already asked by Justice Ko. Now, you were saying about trade secrets, and I don't know if I get you right. If you are the lawyer for Royal Fishing Vessel, let's say if Royal Fishing Vessel is able to find a rich fishing ground, let's say in the middle of West Philippine Sea,
Yes, Your Honor.
then it becomes a proprietary right, almost a trade secret that nobody else can come in and exploit the aquatic resources, meaning only the Royal Fishing Vessel can exploit everything under the ocean in that part of the body of water.
At that particular time only, Your Honor.
At that particular time, what do you mean? Only for that day? So the following day, anybody can come in?
I mean, Your Honor, as long as there is nobody there following them, they can still explore that particular fishing ground, Your Honor.
So,
that's why.
So they do not have proprietary right that only the Royal Fishing Vessel can exploit the resources found thereunder to
Their
the
right-
exclusion of all others.
Well, their right, Your Honor, is to keep the information for themselves, Your Honor, for that informational privacy of theirs, on their trade secret, Your Honor.
So you mean nobody else can share the information except Royal Fishing itself?
Yes, Your Honor. Now, if they discover, other fishing companies discover that, of course, Royal Fishing cannot prevent them from going to that fishing ground also. So at that particular point in time, Royal Fishing will not divulge or disclose their particular location because that's so valuable to them, Your Honor.
So if that is the case, why do you not agree about the use of BMS? Because your location can be shared with the other vessels.
Yes, Your Honor. It would be it's very possible, Your Honor, that they are already retrieving the information as to the whereabouts. For example, Royal Fishing, they're in this particular northern place in Palawan, say Dimipak, no? And they know that they are catching a lot of fish there. A person who handles the information, no, he has already the option to divulge or disclose that, Your Honor, to a competitor. And the effect would create...
But you see, the information on your location is not shared with the other vessels. It
Yes,
is
Your Honor.
transmitted to the central government authority.
Yes, Your Honor.
So how could it be shared with the other vessels? Except that the other vessels may found it also by accident. Is it not correct?
Whether intentional or accident, it can happen, Your Honor. But the fact that the information of their whereabouts is there in the central system, it is prone to be hacked, or other enterprising competitors might, Your Honor.
But I'm glad you mentioned that the proprietary right is as good only for one day until it can be found by the other vessels.
Until such time, Your Honor. Not really one day, Your Honor. They can hold on to that because
They can hold on to that until the aquatic resources are caught or finished.
Because normally, Your Honor, when they communicate, the fishing companies, they communicate through radio, single sideband radios. All the time, the other fishing companies are also monitoring them on their radio frequencies. They're trying to determine or decipher the codes where this company that's performing well are located. So it's possible that they are able to trace that and decode their communication and proceed there. Now, what more if there is already, that's coded, Your Honor. But if the information in the VMS, that's already straight recording, Your Honor. There's no more coding there. So immediately, those enterprising or not, it can immediately determine the exact location of that particular fishing company, Your Honor.
Now, from what I get, from what you're trying to impress with this court, no, para yung first come, first serve. Eh. The first to arrive owns all the aquatic resources that can be found under the water. But this is different from trade secrets. Trade secrets, as defined in our jurisprudence, is very much different. Are you aware of the definition of trade secret as found in the case of Air Philippines Corporation?
Yes, Your Honor.
Can you make the definition? Can you?
It says there that trade secrets shall be protected and privileged, and these are the plans, process, skills.
Plans or process, tool, mechanism, or compound known only to its owner and those of his employees to whom it is necessary to confide it. The definition also extends to a secret formula or process not patented but known only to certain individuals using it in compounding some article of trade having a commercial value. So, now you presented before the lower court two witnesses. I think they are here, a certain Mr. Lim and a certain Mr. Santos, whom you introduced a little earlier as owners of the fishing vessels. Am I correct?
Yes, Your Honor.
Now, except for the judicial affidavits of these two witnesses, no articles, scholarly done or not, no studies, scientific studies were presented before the lower court. Do you think the judicial affidavits of these two witnesses, the credentials of whom you have not even presented before the lower court except by saying that they are owners of fishing vessels, would suffice to say that there is already a trade secret once you are able to discover a rich fishing ground that needs to be protected by the state and by this court.
Yes, Your Honor. At that particular point in time,
But you have only 2 witnesses. Were you able to present any articles, Attorney Naval, that
Your
the
Honor.
rich fishing grounds will constitute a trade secret?
yes, Your Honor, although it was only the 2 representatives of the respondents that testified, it was the witnesses. The witnesses of the Republic themselves admitted that the information are sensitive and confidential, Your Honor, and part of the official's secret.
So you're relying on the testimony made by the OSG themselves and
That's
not
what-
on your own witnesses.
That's one, Your Honor. But it's also a wide-known industry practice that commercial fishing engaged in galunggong operation, they have trade secrets, Your Honor.
You see,
Yeah.
in Cocoland Development Corporation versus NLRC, per Justice Panganiban, the court established that a naked contention of a party on what constitutes a trade secret, absent any substantiation, deserves scant consideration. In other words, any determination as to the confidential nature of technologies, processes, formulae, or other so-called trade secrets must have a substantial factual basis which can pass judicial scrutiny. So the important terms here are substantial factual basis. So you are now telling this court that with the testimony of your 2 witnesses who are both owners, and I'm not even sure if they are also operators of the vessels, will suffice as to constitute a factual basis for the court to consider it as trade secret.
I believe so, Your Honor, that they were able to comply with the 2-part test on knowing whether there is a privacy that you enjoy in order to protect that trade secret. And that is, they already exhibited conduct that they expect privacy and that this is recognized by the society as reasonable, Your Honor.
Now, since it's already 5 o'clock, I have only a few other questions to ask of you. With your indulgence, Attorney Naval,
Yes,
because we entered into a treaty with the other countries, and we are supposed to comply by providing BMS or vessel monitoring system to our vessels, non-compliance of which might constrain the European Commission, among other agencies internationally, to impose some sanctions on us. Now, would you know how many countries entered into these treaties? Do you have any idea? And out of, let's say, 100% or 100 countries, how many of these countries were not able to comply as of this time? Remember, as what I heard earlier, the Solicitor General was saying that in 2014, we already had this treaty, and yet we were not able to comply by providing BMS, and that is why we were provided with a yellow card. But yellow card is not a penalty by itself. It is only an invitation for dialogue, and that is precisely why I think we did pass a law requiring all vessels to have this monitoring system. Now, would you have any idea? Because I have a record here. We have Indonesia, part of the treaty. They are in compliance with all the requirements. We have the United States, which has more than 3,000 vessels. And these are big vessels. Oh, si Justice Rodil is providing me with the countries. All of them were able to comply. So I believe one or 2 countries were not able to comply, and probably one of them is our very own country. So I don't know why you're now asking the Supreme Court to declare FAO 266 as unconstitutional, and again, we may not be able to comply with our treaty obligations. Yes, please.
If I may,
Attorney.
Your
Yeah, please.
Honor, please. Regarding the compliance that we're discussing, these conventions, Your Honor, they focus on highly migratory fish. They focus on the monitoring of those type of fish, not the fish being caught by the respondents here. That's why I distinguished, Your Honor, because the compliance, if FAO 266 will be declared unconstitutional, there is another FAO 260 that addresses
On small fishes,
No,
highly
Your Honor.
migratory. But
Highly
highly migratory birds, highly migratory fish. One of them is yung tuna. Tuna. And it's
Precisely.
one of the biggest industry in the Philippines. I don't know if I heard it correctly. The tuna industry does amount to almost $2 billion a year. Am I correct? Or is this the whole fishing industry? So would you have any idea if we do not comply and our tuna industry might be affected? How much will be? How much of the losses will be incurred by the country because we cannot sell our tuna products to the European Commission and other countries, and we may not allow our ships also to do its work in other high seas. Yes, Attorney Naval?
I have to determine the figures
Yes.
still, Your Honors. But regarding the compliance, Your Honor, as I mentioned, FAO 260 already makes the installation of VMS mandatory to local domestic fishing that are engaged in catching highly migratory fish. So in that aspect, we're compliant already, Your Honor. It so happened that FAO 266 that's being, BIFAR wants to implement, they now deal with small pelagic fish. It covers fish other than the highly migratory fish stock. And these are not actually the focus of the conventions being presented by the petitioners and even mentioned as among the premises of FAO 266. If you will look into the premises of FAO 266 itself, it mentions all the time tuna, highly migratory fish stock. It does not involve the type of operation of herein respondents, Your Honor. The fish that they catch is not highly migratory. It does not traverse different borders. No need for that monitoring that the convention is requiring because it refers to tuna.
No, you mentioned it's already 5 o'clock. My colleague here is telling me it's 5 o'clock. So, but I would like to ask you, you were telling me that the cost of putting up this BMS is worth 200 or 2 billion pesos?
2 billion.
2 billion. For how many vessels? Is that how costly it is? Probably we can ask the Solicitor General if he has any idea on how. So are you implying some kind of corruption in the agency?
Your Honor, it's actually...
Not exactly.
There's actually a pending case, Your Honor. It's in the news, Your Honor. But we're not privy to that except for the details. And they're in a better position to...
Mr. Solicitor, do you have any idea how much it will cost the vessels to put up and buy this equipment?
Your Honor, according to the BIFAR, the installation of the VMS unit is free of charge. The unit itself and the installation, according to BFOD, is free of charge.
The unit is free of charge. It will be provided to the vessels without any cost to them.
Yes, Your Honor, the BFAR
But it
people...
will cost the government. How much does the governor have to buy it? Do you have any idea what is the pending case all about? Is it before the ombudsman or not?
Ombudsman, Your Honor. It's in the news, Your Honor. That's
It's
why.
in the news.
Your Honor, the cost for BMS, with your permission, is
Yes,
around
yes, Mr.
80,000 pesos.
80,000
But the
pesos
government
only.
will be the one to shoulder it, not the vessel owner. The installation is also free, although the monetary value is something like 5,000 pesos.
So, do you have any idea how many vessels all in all?
Thousands
That
of
will be
vessels.
Thousands of vessels, but
Yes.
you multiply it by 80,000, I don't think it will reach billion of pesos, 2 billion. So, how were you able to reach that 2 billion cost, Attorney Nabal?
It's in the news, Your Honor.
It's in the news.
Yes, Your Honor. Please.
But you are not privy where the news came from.
Yes, Your Honor.
So, Marites lang daw yon, galing kay Marites.
It's in the news, Your Honor. Please.
Anyway, now, I mentioned already that in the United States, they have more than 3,000 to 4,000 vessels, and all of them are equipped with the said BMS. So with Indonesia, which is the largest archipelagic nation, has so many ships, and yet they do not have any complaint that all of the ships are equipped with the same BMS.
Again, Your Honor, because they are engaged in fishing highly migratory fish stocks.
Now, you also mentioned earlier about some biblical story that some disciples were told to throw the net and they were able to catch fish. Do you think it's a trade secret or it's a miracle?
Your Honor, of course, Your Honor, that's a mystery. That still remains a mystery. But like what I mentioned,
But definitely it's not a trade secret because they do not have trade secret.
it's a mystery, Your Honor.
So, sabi ni Justice Sam, continuance daw. If with the permission of the Chief Justice, it's already 5 o'clock. So we don't want to keep the audience waiting. No? Okay. Thank you, Chief.
Thank you, Justice Jolo. Since it's about 10 minutes past the 5 o'clock, we'll have continuance. Clerk of Court, the order is this afternoon, parties completed the presentation of their arguments. Justices Monet Singh, Antonio Co, Japardi Mampao, and Justice Jolo Lopez completed their interpellation. For lack of material time, the oral argument shall continue on November 14, Tuesday? No, October 24, Tuesday next week. Also at 2 o'clock in the afternoon. Any other matter?
There are no other matters, Your Honor.
14? Okay, I'm sorry. We have to reset it because some of the justices are traveling. The continuation of the oral argument will be held on November 21, Tuesday, at 2 o'clock in the afternoon. Clerk of Court, any other matter?
There are no other matters, Your Honor.
There being no other matters, the court hereby adjourns this session.